Hi there. My name's Richard Joel Jr. I'm an attorney in Oradell, New Jersey, and that's in Bergen County. I am a family law attorney and I've been practicing for 20 years. I'm going to review with you the divorce process in New Jersey. The goal of every divorce proceeding should be to reach a fair and reasonable settlement under the circumstances, one wherein each of the parties can live with it. If you can't reach a settlement, then you'll have to have a trial on the matter. I'm going to briefly review with you the steps in a divorce. The first step is to file a divorce complaint. In Bergen County, that's filed in Hackensack, and that's part of the family part of the Superior Court. The filing fee for a complaint is $250. Plus, if there's children involved, you'll have to pay an extra $25 fee for educational program that they have. After you file the complaint, you will receive a filed complaint back. You will have to prepare a summons and then serve the filed complaint upon your spouse. Your spouse could either acknowledge service by signing an acknowledgement, or you'll have to have a process server such as a private service entity that serves process, or the Bergen County Sheriff or other county sheriff to serve your spouse. After your spouse is served, the clock starts ticking. Your spouse will then have 35 days to file an answer with the court. If the spouse does not file an answer within that 35 days and does not have the time extended, then you can file for a default. If you file for a default, you will have to put your spouse on notice, and at that time your spouse can make application to file an answer. Okay, let's assume that your spouse has filed an answer. After that point, you have 20 days to file a case information statement. A case information statement is a form required by the court which has a detailed financial analysis of the parties. You'll have to set forth all your income and expenses and all of your assets and liabilities. You will also have to attach your tax return and your last 3 paychecks. And this is a very important document wherein the parties and the court will rely upon in reviewing the matter. After you file your case information statement, you will have a case management conference. In Bergen County, the court will require that the attorneys appear with the clients. Not all counties do this, but this is the practice in Bergen County. The parties and the attorneys will appear, and the court will review all the issues in the matter, such as custody and parenting time, alimony, child support, equitable distribution, counsel fees, insurance, etc., just to see what's at stake. The court will also review what discovery is needed, what possible motions will be involved, and will try to crystallize the issues in the matter. After you have the case management conference, you will get a case management order that'll set forth what has to be done in the time frame that you have. It will also indicate the discovery schedule for the matter. After the case management conference, you will engage in discovery. Discovery can be done with interrogatories, which are written questions sent to the other party for them to answer, by document production, where you have document requests to the other party where they have to furnish the documents to you, or you can have depositions, which are not very common and are usually only used in high net worth cases. They can be very expensive. And also you can serve subpoenas to find out information also on third parties. After you've engaged in discovery and all that has been completed, your case will be ready for an early settlement panel. An early settlement panel is a volunteer panel of family law attorneys with a high level of experience that will receive submissions from each of the parties. The parties will submit what their position is for settlement and what they want, and provide backup documentation such as the case information statement for the case. The settlement panel will review these submissions, and on the day of the early settlement panel, will meet with the attorneys first to review all the issues in the matter and to get feedback. After the panel has discussed the matter with the attorneys, the clients will be invited in, and there will also be some more question and answers conducted. And then the panel will give their view of the case and their recommendations for settlement. If the parties settle the matter at the early settlement panel, the parties can be divorced that day. If the parties cannot resolve the matter at the early settlement panel, then the court will refer the matter to economic mediation. The parties will agree on an economic mediator to hear the matter. The parties will submit their case information statements and any other relevant information to the mediator. The mediator will have an initial session with the attorneys to discuss the matter, and then we'll schedule a date for the attorneys and the parties to attend the mediation usually at the mediator's office. There'll be a mediation session conducted. If done in a skillful manner, it can be very helpful in resolving the matter. If it's not resolved, then the mediator will report back to the court that the matter could not be resolved, and then the court will set the matter down for a settlement conference or a trial date. The court will then have certain court dates where the parties and the attorneys will appear. There'll be conferences to try to resolve it, and if it can't be resolved, eventually a firm trial date will be set in the matter. If there's going to be a trial, most judges will require certain pretrial submissions. This can be very expensive, so every opportunity should be made to fairly and reasonably settle the case. If it can't, then you'll have to do the pretrial submissions. And when a court does try a case, it's not necessarily all day or in consecutive days. You could appear at 11 o'clock on one day, testify for a couple hours, and then be told to come back a few days later or weeks later. Eventually all the evidence will be in. There'll have to be post-trial submissions after that, and then the court will make a decision thereafter, and it can take a good deal of time. The court has certain constraints when making a decision in a certain matter and cannot be as creative as the parties are. So it's, again, people should try to resolve the case because they know their situation better than anyone. A judge that hears a matter is only hearing testimony from the witnesses and receiving certain documentation as evidence and does not know the life story of each party. The judge tries to make a fair decision under the circumstances based upon the statutes, the case law, and the evidence presented. But there's no way that a judge can know the situation better than the parties. After the court makes a decision, the parties have to make a decision whether they're okay with it or if they're going to file a motion for a new trial or for reconsideration of any matters or to file an appeal in the matter. But I just gave you a brief overview of the divorce process in New Jersey. And you should always seek legal help when proceeding with a divorce because a lot of times it's just your one shot, and you should make sure that you're receiving good legal advice and are proceeding appropriately in the case. Again, my name is Richard A. Joel Jr. I'm an attorney in Oradell, New Jersey, and thank you for your time, and I hope this was helpful.